Hello, everybody, and welcome to History/Law Bite number 194, dated February the 24th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Martin versus Hunter's Lessee, 14 U.S. 304, 1816. Martin versus Hunter's Lessee was a landmark U.S. Supreme Court decision which put to bed the then open legal question over whether or not the U.S. Supreme Court had the final say on matters of federal law that had originated in state court. Okay? From this decision, the Supreme Court asserted that it did. Okay? Believe it or not, a lot of the things regarding the power of the Supreme Court were still open questions in the early 19th century in the U.S., and it took many decisions to firmly establish the court's power as the final arbiter of constitutional questions. Okay, so in this case, Martin versus Hunter's Lessee, we're on the subject of land confiscations during and after the Revolutionary War. With respect to this case, the state of Virginia, like many of the American colonies in rebellion, had enacted a law during the Revolution to provide for the seizure of lands owned by loyalists to the British Crown. Okay, something that would in effect be overturned with the 1783 Treaty of Paris that brought an end to the Revolutionary War. So here, Denny Martin, who was a British subject, inherited a large amount of land from his uncle in 1781. Not long afterwards, the legislature of Virginia enacted a law voiding the land grant and transferred it back to the state of Virginia. Okay. In turn, they would transfer that land to an individual by the name of David Hunter. Okay. However, as I said before, the 1783 Treaty of Paris officially carried the day, as it was to respect the property. Mandated the respecting of property that was owned by loyalists, to prevent further land seizures of loyalists to the British Crown, as a gesture of cooperation between Britain and the new United States. All right. So this matter obviously found itself litigated. All right. Reaching the Supreme Court of Virginia, which ruled that the land confiscation and transfer to Hunter was perfectly legitimate. All right. In spite of the 1783 Treaty of Paris. Not because it thought that Virginia law was superior, but rather because it felt that the Treaty of Paris did not cover this specific issue. Where they got that from, who knows? All right. So on appeal to the Supreme Court of the United States, the court obviously disagreed with this conclusion and reversed the holding based on the language contained in the Treaty of Paris of 1783, requiring the property of loyalists to be respected, as federal treaties via the Supremacy Clause would obviously supersede any state laws to the contrary. Virginia was clearly wrong for this, and certainly for awarding the property to Mr. Hunter. Okay? On remand back to Virginia, the Supreme Court of Virginia basically told the U.S. Supreme Court to kick rocks, holding that the U.S. Supreme Court had no jurisdiction to overturn its judgment here, that Section 25 of the Judiciary Act of 1789, allowing the Supreme Court to hear appeals from state Supreme Courts, was unconstitutional. All right? Essentially, that section allowed the Supreme Court to hear, appeals on matters of federal law from state courts. All right. In this case, in all likelihood, that would come from state Supreme Court. And the Virginia Supreme Court held in their opinion that that was unconstitutional. Again, I don't know where they're getting that from. Okay. So most of these, this actually was largely based on predecessor case here, known as Fairfax Devicey versus Hunter. All right. Fairfax Devicey versus Hunter's Lessee, from 1813. All right. And in this suit, Martin versus Hunter's Lessee, we see the matter appealed back to the U.S. Supreme Court, all right, which, needless to say, in its opinion, dealt a death blow to the opinion of the Supreme Court of Virginia, all right, in a unanimous, near unanimous opinion from the Supreme Court of the United States, via Justice Joseph Story, another legend of the time. The Supreme Court ruled that the section of the Judiciary Act of 1789, Section 25, giving the Supreme Court the authority to hear matters of federal law from state courts, was absolutely constitutional. Okay? The issue presented to the justices was whether that was constitutional, whether that section of the Judiciary Act of 1789 was constitutional. And the Supreme Court ruled practically unanimously that it was. The opinion drew one concurrence by Justice Thomas Johnson. But Story overwhelmingly spoke for a near unanimous court in holding that the Constitution via Article 3, okay, Section 2 specifically, Clause 2, describing the court's original and appellate judicial power, all right, as well as the Supremacy Clause in Article 6, Article 6, Clause 2 of the U.S. Constitution, gave the Supreme Court the obvious authority to hear this case and have the final say on the issue of federal law that was in dispute in this case, all right? And so from the decision, Story goes in great length to explain and lay to bed the bogus arguments made by the Supreme Court of Virginia that the Supreme Court did not have the power to hear this, asserting the long, obvious description of judicial power in the Constitution, okay? And the obvious language of the Supremacy Clause, giving the federal courts obvious supremacy over those of state courts when federal law was in question. Indeed, if the Supreme Court could hear issues and overturn actions of state legislatures as well as state executives, why were state courts any different? Okay, obviously they are no different. Okay, so this decision essentially put that issue to bed forever. All right. Now, in another case, Cohens versus Virginia, handed down a few years later in 1821, the Supreme Court established itself as the final authority on all cases involving federal questions from state courts in criminal matters. This one, if you want to narrow it down specifically, established the court's final word with respect to federal civil matters originating in state courts. And Cohens versus Virginia in 1821 would deal with the matter with respect to criminal matters of federal law originating in state courts. All right. So that is Martin versus Hunter's Lessee, 14 U.S. 304, 1816. All right. So if you have any questions or controversies about this case, getting into the further details with respect to judicial power over state courts, leave them down below and I'll be happy to answer them. Hope you learned a thing or two from this history bite. It's an interesting case involving the extent of just how great federal judicial power really is. All right. If you have not subscribed to my YouTube channel, please do so now. It would be greatly appreciated. I appreciate you so much for listening. You have no idea, folks. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.